Welcome to the National Crime Victim Law Institute's online toolkit video on using pseudonyms to protect crime victims' identities in criminal cases. This video provides attorneys with a broad and introductory overview on this topic. Some victims want to be publicly identified for various reasons, and assuming that they're making an informed decision, we support those choices. But many other victims may want or need to maintain their privacy, and referring to those victims by a pseudonym throughout the criminal case is one of the tools that can help. Think of using pseudonyms to achieve two objectives, privacy and protection, or the two Ps. Proceeding by a pseudonym allows the victims to maintain their privacy in public records, and it protects the victims by minimizing unwanted publicity and harassment. The loss of privacy has serious ramifications. A single reference to a victim's name in a public record can lead to the inclusion of that victim's name in a story on the internet, and details of a crime that makes its way online can potentially stay there forever and easily discoverable by a simple Google search. Among other things, unwanted publicity can cause some victims to suffer additional trauma symptoms and interfere with the healing process. It may also have a chilling effect on the victim's willingness to report crimes. So, in that sense, privacy is very much like oxygen for many victims. It is critical to their recovery and their ability to access justice. Now, why this method over other common procedures such as sealing records and using initials? Well, seals can be lifted, and sealed records in some jurisdictions are routinely lifted at the end of a case. So consider filing under seal in conjunction with the use of a pseudonym for additional protection. And initials may not adequately mask the victim's true identity in public records. For example, in small communities, the use of initials might be enough to tip off who the victim is, particularly if the victim has unusual initials, or if the victim's family members are also identified by the record. So if you have the choice, elect to proceed by a pseudonym instead of initials. At what point in the criminal case should you seek the use of a pseudonym for the victim? As soon as possible. Even at the reporting stage, law enforcement can identify victims by pseudonyms in the police report. And what exactly should you be seeking? You want everyone, law enforcement, the prosecution, the defense, the court, and all of their agents to agree to refer to the victim by a pseudonym in all records and all proceedings in the case. You will also need to ask for a protective order. For example, if a court allows a victim to proceed with a pseudonym but allows disclosure of the real name to the defendant, you want to ask for an order that forbids defendant from releasing the name to others by way of any method, including online social media platforms such as Facebook. This provides a court with a stick in the form of criminal contempt if defendant violates the court order. Even if the court order prohibits disclosure of the real name to defendant, you should anticipate the possibility that defendant may end up getting and revealing the victim's name by securing that protective order. And of course, the protective order should cover the actions of defense attorneys, prosecutors, and other players in the case. Now, how do you go about doing this? Well, the first and most obvious avenue is to ask, right? You want to ask law enforcement when the victim reports the crime. You want to ask the prosecutor and the defense to agree to the use of a pseudonym in all filings and all proceedings. And, if necessary, you need to take legal action. Now, depending on where you are in the process, you may need to petition for a writ of mandamus or prohibition, or file a motion in the criminal case. When preparing to litigate victims' rights, you want to keep in mind two important rules. First, remember that a legal right is not always explicitly spelled out in a constitution, a statute, or a rule. A particular legal right may be implied by other existing constitutional, statutory, or rule-based protections. So, for example, the word privacy is not explicitly found in the United States Constitution, but the Supreme Court has interpreted the Constitution as including the right to privacy in several cases. Second, when litigating victims' rights, be sure to think broadly and expansively. You want to look beyond the obvious. For example, if your jurisdiction has a law that explicitly states that crime victims have the right to use a pseudonym during the criminal justice process, then great. That makes your case much easier. But if that right isn't explicitly spelled out anywhere, don't stop the inquiry. What you want to do is to be sure that you examine all available rights and you make the argument to the court that those existing rights should be construed as providing an implicit right for the victim to use a pseudonym. So, for example, argue that the victim's right to privacy under federal law and state law supports the use of a pseudonym. Or argue that the victim, like the general public, has a right to access courts under the First and 14th Amendments, the Privileges and Immunity Clause, or the state constitutional equivalent. And that right of access would be imperative if the court were to require this particular victim to proceed with his or her name in the public records. Cite research that tells us that the loss of privacy and harassment from unwanted publicity can cause a chilling effect on the victim's willingness to report crimes and to access justice. And if your jurisdiction has a law that provides a right to protection or the right to be free from intimidation or harassment, argue that those rights also support the use of a pseudonym to protect the victim's identity. Just look to the facts and news reports and case law for examples of what can happen to crime victims when their identities are revealed to their communities. So remember the two rules. The right to use a pseudonym can be explicitly provided for in your jurisdiction's laws, or it can be implied by other existing rights. And remember to look beyond the obvious. Now let's take a brief look at the competing rights that courts would often need to consider when litigating this issue. And we'll start with the investigation stage. Now, during the investigation stage, the media may challenge the use of a pseudonym in a police report and argue that they, and the public, have a right to know the real identity of the crime victim, particularly in a high-profile crime. On the one hand, we have the right to access public records. But remember, this right is not based on the Constitution. It is based in statutory public records laws. So any relevant constitutional victims' rights that you may be able to assert should trump. Also, many public records laws include a privacy exception, whether explicitly stated in the statute or as construed by the courts in case law. So when weighing the respective rights during the investigation stage, a victim's rights should prevail over the public's non-absolute statutory right to access public records. Next, how about competing rights at the charging stage? Referring to a victim by a pseudonym in a charging instrument implicates a defendant's constitutional right to be informed of the nature and charge against him or her and to avoid double jeopardy. The law arguably allows a victim to proceed anonymously at the indictment stage or the information stage so long as the defendant's charging instrument provides legally sufficient notice of the charges and enough information on the identity of the victim to allow the defendant to prepare his or her defense. Many courts across the country have rejected defendants' argument that a charging instrument was defective simply because the victim's name was not fully included on the ground that other facts alleged in the charging instrument, such as the dates and times of the incidents, the location address, the victim's online screen names, and so forth, were sufficient to enable defendants to formulate a defense and to protect against future double jeopardy. Now, when talking about using a pseudonym in all records and proceedings through trial and beyond, the issue is more complicated. Depending on the circumstances, you may face a challenge from the media or defendant or both, and the relevant rights in question may differ. The public, including the media and defendant, have a right to open proceedings under the First and 14th Amendments, and defendants in criminal trials have a right to open proceedings guaranteed by the Sixth Amendment. But case law establishes that these rights are not absolute and can be limited under certain circumstances. Argue that even the use of a pseudonym during trial does not infringe upon defendant's right to a fair trial. You tell the court that a proper weighing of all relevant rights and policy considerations support the use of pseudonym throughout the case. And remember, no matter which stage you're in, if you need help with these litigation challenges, contact NCVLI for technical assistance. Now, what if you just entered the case and you learn that some public records already reveal the victim's name? Sometimes this can happen by accident in cases where all the parties have agreed to use a pseudonym. For example, a party may have attached as an exhibit a receipt to a filing and forget to redact the victim's name from the exhibit. In such instances, the remedy is to seek redaction and substitution. This means that you should ask the court for an order directing the redaction of the victim's real name from all previously filed records, including court opinions, and then you substitute the redacted versions for the previously filed versions. Now, what if the record containing the victim's name has already made its way online? Well, first, you still want to seek redaction and substitution of the record in the case file. Second, you contact the online site that's linking to, or has a copy of, or that's referencing the unredacted information. So, for example, contact Google, FindLaw, Westlaw, Lexis, news website, blogs, and so forth. And you ask that they remove the document that's on their website and replace it with a legally accurate redacted version, or you ask them to update their links, or you ask them to use a pseudonym in their stories. And if they're unwilling to do so after receiving a cordial letter request from you, the court order may be necessary to require that they do so. As a final note, NCVLI has flowcharts and other resources on this topic that are available in our online toolkit library. On your screen is a snapshot of one flowchart that guides you through the basic process of securing the use of a pseudonym in a criminal case. This concludes our overview of the use of a pseudonym to protect the victim's identity in criminal cases. Thank you for viewing this video. Please be sure to visit NCVLI's website for additional resources.